माननीय सभापति जी,
Honorable members, the matter under Rule 377 shall be laid on the table of the House. Members who have been permitted to raise matters under Rule 377 today and are desirous of laying them may personally hand over text of the matter at the table of the House within 20 minutes. Only those matters shall be treated as laid for which text of the matter has been received at the table within the stipulated time. The rest will be treated as lapsed. Honourable Minister to reply.
Thank you very much, sir. From yesterday, we've had this discussion on the chartered accountants, cost and works accountants, and the company secretaries amendment bill. The Minister of State has been seated in this House following the debates, whilst unfortunately I couldn't be here as I had a reply to give on the finance bill in the Rajya Sabha.
It was the longest reply in Rajya Sabha.
Is that so? Thank you. But there was also very interesting and detailed discussions, so I thought it only right that I give reply for the issues raised by the honourable members. And so is the spirit of the discussion on this bill here since yesterday, and I'll seek your indulgence for giving a bit of an elaborate reply, because many of the issues have been raised in great detail and calibration. So permit me to be a bit elaborate on my reply. So the current set of amendments for not just one of the institutes, but for three simultaneously: the Chartered Accountants Institute, the Cost and Works Accountants Institutes, and also the Institute of Company Secretaries, are being brought in as a consolidated one set of amendments, as one amendment bill. Let me start by addressing that concern which was voiced by one of the members, that how come you're bringing all the three together? Are they going to be governed by all the three together as one act? No, sir, there's no proposal at all to have a single legislation for all the three institutes. They will be governed as they are governed now by their respective acts. There are three separate acts, and they will be governed by the three separate acts.
So there will be a coordination committee headed by the
Please.
Sir, so they will be governed by their respective separate acts, and this is just a consolidated amendments bill. And why should it be in one bill? Because largely, while the acts are separate, three different, they are worded, and the spirit of the flow of the acts are comparable, and therefore the amendments which are brought in, so that there is a greater comparability between the functioning of the three, the amendment is being brought in as one separate but one integrated bill. And these amendments have not been brought in as it is without much of a work. Quite some time, different committees have gone into it. Particular and the most recent one being the Meenakshi Datta Ghosh Committee, which had come up with several recommendations. It was formed in 2017, sometime in April, and which had given its recommendation by 2017, September itself. And many of these recommendations given by the Meenakshi Datta Ghosh Committee, with minor tweakings, have been brought into this Act. So why is it that we're bringing it now? And of course, after quite a lot of consultation, is in the last 8 years, we've witnessed considerable change, progress, growth, and also economic development, with a lot of legislative support coming in to make it easy for companies, both for entry and for exit. The IBC code, and periodically amending the IBC code. As you know, this House is quite aware that we've come periodically to amend the IBC Act, and also to make it sure that IBC Act or the Companies Act, which also went through quite a few amendments, and the LLP Act, all of them represent the rapidly changing economic profile, and also making sure there's more space given for LLPs, for instance, under which come the startups and so on. So, since the LLPs are also gaining a good space in the economy, it was necessary for us to have a robust audit certification from the professionals. Now, it is also important that audit certification and also the quality of audit, therefore, will have to be kept in mind and improved so that there is a favorable investment climate in the country. And above all, when all of us are looking towards greater transparency, better managed, board-driven managed companies, and so on, the sanctity of an audited financial statement gains so much of an importance that we need all the stakeholders, whether they are promoters, whether they are investors, whether they are, the employees, all of them should have greater confidence in the kind of statements which the audited statement is certified by a chartered professional. And therefore, at this time, if there is a necessity for reviewing the SR, the self-regulatory kind of a mechanism with which most of these institutes function, we are only doing it because we'll be globally aligning ourselves. Most of the countries, whether it is the US or the UK or Australia, Canada, South Africa, all of them have such systems. In fact, in the United States of America, every state has its own body, and not just one, there are many bodies within that, and the governor of the state appoints many of these members who regulate these bodies and so on. So the world has moved further and further away to have a greater, transparent, accountable, and also a process in which everybody sits in to judge and also to see how the functioning happens. And therefore, at this time for India, to look at how these three institutions can be, because they are very important pillars of corporate governance, especially together with the board of a company and the management of the company, this would be the third most important pillar for greater professionally managed and efficiently managed companies. And that is why we need to have these amendments brought in, and brought in because also from 2006 globally, you see an international awareness and also a body which now has come together of independent regulators, and it is a big forum, the International Forum of Independent Regulators, is also now coming to say what are the guidance that globally we can give to each other, which are the best practices which can be adopted. And therefore, we have thought it fit that at this stage we come up with this consolidated amendment bill. I understand also that concerns have been expressed by members if this is going to compromise the autonomy of these institutions. And in particular, if the coordination committee which is coming in will change the way in which the independent functioning has been affected all these years, will that get affected or will that get compromised? I want to state up front, sir, that there is no proposal here or no intention here to impinge upon the autonomy of these three institutions. Not at all. There is no proposal, not even a faint intent to dilute the autonomy of these three institutions. The three institutes at present are responsible for all the functions concerning the qualification, licensing and regulation of their conduct. And they will continue to perform those functions. Let this be recorded. They will continue to perform those functions. As regards the fee from the students, and the institutes had earlier also the full powers, that is also not being touched. So even that will continue. In fact, the Council is being given full autonomy to decide fee as regards registration of members and certificate of practice. At present, to increase the fee for registration of members and certificate of practice beyond a limit prescribed in the Act, approval of the government is required. But this is being dispensed with. The Council will have full powers to fix even such fees. In fact, that is being given, and the government, which had an indirect role in it, wherein after a point the Council had to come back, that is also being given back to the Council. The Council will also be continuing to administer the funds as per the provisions of Section 18, and there will be no government role in that as well. So there is actually no change even in the composition of the Council responsible for the management of the affairs of the institutes.
What about disciplinary mechanism?
Sir, in the proposed amendment, sir, the Council shall continue to constitute these bodies, the Board of Discipline and the Disciplinary Committee, as per the existing practice. Government will not constitute them. I'd like to reiterate that government will not constitute them.
Chairman will be from outside.
So there will also be no
Nothing is on
change
record.
in the number of members in these bodies. However, sir, majority will be of non-members of the institute, which is the global best practice which we want to bring in here. Being elected members, sir, President and Vice President shall not be heading the disciplinary committees, and the Council members shall not head the Board of Discipline to avoid conflict of interest. That probably, therefore, responds to some of the questions which are being raised even before I've started speaking, sir. So the collaboration and the greater responsibility to the Council of the Institute for nomination of experts and persons of eminence has been proposed, and that is through these amendments rather than taking away their powers. So, in a way, it is they who give the names, and it is that which gets appointed. Very quickly, just to get a picture of what we are talking about. So, in the Institute of Chartered Accountants of India, the Board of Discipline, the BOD, existing position since 2006, sir, is the BOD is a 3-member body. There is a presiding member officer who is a council member, 1 member who is nominated by the government, 1 member who is nominated by the council. What we propose in this set of amendments is for the Institute of Chartered Accountants of India, the presiding officer shall be a non-CA nominated by the government from out of the panel prepared and provided by the council itself. 1 member who will be a non-CA nominated by the government, again from out of the panel prepared and provided by the council itself. The other member will be nominated by the council from out of a panel of members of the institute to be prepared by the council. Now, this is the proposal, and this again falls back on the council itself to propose the names, give the panel, from which the government appoints somebody. And having a non-CA as presiding officer is very much in line with the global best practices. And if people have asked a question saying, how will a non-CA understand what the whole thing is about? It's a technical thing. They may not be able to understand. Absolutely not founded at all, sir. these doubts don't have a basis, because everywhere else in the world, a lay person sits as a chair while the other members are all CAs, and they can always guide the council or the BOD to take a call. And this brings in greater transparency, a greater fresh outsiders approach to the issue. So in the disciplinary committee, sir, if this is what is on the BOD, the disciplinary committee, which is a 5-member body, the existing composition since 2006 is that the presiding officer is a president or vice president of the council itself. 2 members are nominated by the council. 2 members otherwise are nominated by the government. So that is the existing structure. Now, what we have proposed in this set of amendments is that the presiding officer shall be a non-CA nominated by the government, but from out of the panel prepared and provided by the council. 2 other members are non-CAs nominated by the government again from out of the panel which is prepared and provided by the council. Then 2 members are nominated by the council from out of the panel of members. The institute shall prepare this panel of names being prepared. Sir, I move, similar is the structure for the company secretaries and the cost accountants institutes also. So I very quickly move to the related issue, Honourable Chair, when you from there asked, saying, won't it defeat the purpose of avoiding conflict of interest between the administrative and the disciplinary arm of the institute? A very concerned question. And I wanted to answer this by saying the panel of the presiding officers and the lay members will be prepared by the council in accordance with the regulations which will be framed. So they'll have to go by that. They will be experts in the different fields as mentioned in the bill. So it's not going to result in conflict of interest because the regulations will guide them. The proposed amendments in the 3 acts governing the 3 professional institutes without compromising their autonomy seeks to make the councils or the institutes themselves more responsive and accountable. And therefore, these steps are being taken with a conscious attempt to make sure that we are neither undermining the autonomy nor are we bringing a situation of conflict of interest, which is a question which you have very rightly raised, sir. Sir, as regards the coordination committee, Professor Saugata Roy has been very concerned about it from the minute I started speaking. As per the proposed bill, the coordination committee will comprise of the president, the vice president and the secretaries of the 3 institutes, quarterly meeting of which shall be held under the chairpersonship of the Secretary, Ministry of Corporate Affairs, which is the administrative ministry of all the 3 institutes. It may be noted here, and I think it's very important for us to seize this fact, that the 2 other institutes, Institute of Cost Accountants of India and ICSI, have not objected to the constitution of such a committee. After all, when we did stakeholders consultation, all the institutes gave their respective input, and the ICSI and the cost accountants did not have an objection. The ICAI, in a meeting dated 23 September 2019, under the chairmanship of the Secretary of Corporate Affairs, had also agreed for the constitution of a coordination committee. Now, the coordination committee, sir, has been proposed for the development and harmonization of the 3 professions, and therefore, this is not going to undermine them. In fact, if I can move quickly on giving comparable examples, IIMs among themselves have a coordination committee. Indian Institute of Management. IIMs have a committee among themselves, coordination committee. IT also has a coordination committee among themselves. And these have actually been very effective in having greater synergy among these institutes. And in fact, if I may highlight, and it might be time appropriate for me to highlight, that the IT's committee, the coordination committee, is headed by the minister himself. So this worry that, that profession's person with expertise in that field, experience in the field, only can sit as a chairman is completely disproved by the fact that the triple IT's chairman is the minister himself. So similarly, the point that I would like to highlight here is in the year 2000, the ICSI, that is the Company Secretaries Institute, and the ICAI, Chartered Accountants Institute, and also the Institute of Cost Accountants, among themselves, formed a coordination committee through an MOU. So it's not as if this is the first time they are bringing a coordination committee. In the year 2000, through an MOU, these three institutes formed a coordination committee, but it has not just taken off. Actually, the absence of coordination is what is standing out, despite this having been formed in 2000 through an MOU. So, and again, to highlight for the reference of the honourable members, coordination committee will not be issuing directives at all. It is more to manage the funds of the institute and other things, which people tend to doubt if there will be a direction given by the coordination committee about how resources will have to be used. No, not at all. It's not going to be doing that. And therefore, that aspect, the governance and the management of the resources of the institutes are going to be governed by Section 18, which is the practice which is existing now. Also, sir, a non-standing committee. For us who are constantly referring to standing committee in the Parliament, this expression was a bit of a discomforting one for me, but that is it. It is called the non-standing committee of a particular institute which has been proposed by the ICAI, saying you can have a particular institute having a non-standing committee and have this taken care of. When we started talking about the absence of a statutory backing for this kind of a thing, this was suggested, saying a non-standing committee could work in that place. Sir, in order to make the coordination effective, I think it's important that periodic meetings with the given structures held, and that is only possible through a very institutionalized framework, and that is why we thought we should go through this route. So there, I move slightly to a different issue, sir, that again on the composition of the BOD and the DC has been repeatedly raised by all members. I think the global best practice is something which I already mentioned. Globally, the conduct of chartered accountants, particularly who are auditors of public interest entities being those which have a certain stipulation, if I can just go to state them in specific. What are public interest entities, sir? They are, first of all, listed companies, sometimes even unlisted companies, but which have over 500 crore paid-up capital, or which are over 1,000 crores of annual turnover, or those with over 500 crores in terms of loans, debentures, and deposits. So these are the public interest entities. So globally, auditors who deal with public interest entities are regulated by independent regulators. I'll just name a few for it. In the United States of America, it's the PCAOB, the FRC in UK, the ASCI, the ASCI in Australia, the IRBA in South Africa, the CPAB in Canada, all of whom are independent regulators. So even in India, on similar lines, we set up, I think in 2018, the NFRA, the National Financial Reporting Authority. The full-time members of NAFRA at present are not members of the institute. So if NAFRA, which deals with auditors of public interest entities, both listed and unlisted because of the size of the operations, the proposed amendments which aims to bring that independence and autonomy with members who are not members of those institutes also becoming a part of the disciplinary committee, I think we are only matching ourselves with global best practices. And there's nothing to worry if we are undermining our institutions. On the contrary, we'll be strengthening them because greater independence, greater transparency, and greater outsider looking into the affairs of the bodies. As I said earlier, sir, the International Forum of Independent Audit Regulators, which was a body which has come into existence in sometime 2006, have been suggesting these, and we are only aligning ourselves with the global best practice. Also, the guiding principles which have been given by the International Federation of Accountants is also something which is an international NGO, and it's a global advocacy organization. In fact, the ICAI, the Institute of Chartered Accountants of India, are a member of this International Federation of Accountants, and they have given these guidelines. So we are taking that on board. Again, coming to the good work which standing committees of our parliament do in these regards, 2003, sir, the Standing Committee on Finance, whose tenure was between 2004 and 5, in its 11th report, discussed a lot of these amendments. And I would like to quote few sentences from there. Quote, "The committee recommend that such a body should be headed by a person not below the rank of a joint secretary belonging to the legislative service. 2 members should be from the council, and 2 shall be outside experts from the field of law and accountancy," unquote. So that's the standing committee of this House sometime in 2005 mentioning the same thing, and it has taken us nearly 15 years to arrive at that step now. As I said earlier, in UK, the United States, South Africa, have all adopted this, and it is not something which we are doing for the first time. So there were questions raised about why a complaint pending completion of inquiry is being kept in public domain, which is also going to be enabled now. So this is a question which Honourable Member Bhartruhari Mehtabji raised, Adirji raised, saying putting status of actionable complaints in public domain or entering them into the register of members, would it raise doubts about how the members being treated? Will it be victimizing him? Will there be an element of harassment? And so on. That's not the intent at all, sir, and does not intend to victimize the member. The manner and the interval of putting such information out in public domain and also entering in the register of members shall be in accordance with the regulations framed by the council itself. So there cannot be an element of discretion saying, I don't like somebody, so I'm going to put them there and publicly shame them or victimize them. Cannot happen. It may be noted that the 2 other institutes, which is the company accounts and also the company secretaries, have not at all objected to this proposal. So mind application has happened from the different institutes, and we've gone only in the direction in which majority opinion has emerged. So the rationale for provision of audit by a panel of auditors maintained by C&WA was raised by Honourable Member Supriya Sule. She questioned as to why this should happen. Sir, at present, the ICAI, as per the provisions of the existing Chartered Accountants Act, the Council may appoint any auditor to audit its own annual account. And in this proposed amendment that we are bringing in now, we have provided that the Institute will appoint an auditor from a panel of auditors which is maintained by the constitutional authority, which is the CAG. So you can always pick up an auditor. Maybe that auditor is already in the list of CAG. That's fine. But now we are saying, turn it this way around. Please do pick it up from that panel of auditors which is listed by the CAG, which is a constitutional body, just gives a greater heft to the audit of the institutes. And therefore, it's, I think, a progressive step towards bringing greater transparency. And again, on this matter as well, the company Secretaries Institute, as a matter of practice, is getting audit done through a panel of auditors maintained by the CAG already. So if one of them is doing it, it might be a best practice the others also adopt. So there were legitimate concern about why the term of the council members, the Chartered Accountants Council, is being reduced, whether it would limit the chances of others and so on. Just for the clarity, sir, at present the term of the council of the Chartered Account, ICAI, is for 3 years, and a member can remain a member for another 3 consecutive terms, which means a total period of 9 years. The ICAI has been demanding to increase the term of the council for a long time. They've been asking for it for a very, very long time. Further, the term of the council in the Company Accountants of India and the ICSI is already 4 years. It's already 4 years. The provision in the CA Act for the ICAI is being aligned with the rest too. So while the term of the council is being enhanced to 4 years from 3 years, the term of a member is being restricted from 3 terms to 2 terms. So in the place of 9 years, which he was otherwise entitled in the present dispensation, a member can remain in the council only for 8 consecutive years. So 2 terms, 4 plus 4, 8 years, substantial time for doing great service and reform. So there was this distinction made between an auditor, the individual, and an audit firm. Currently, sir, there is no provision for a separate register of firm and proceedings against the misconduct of firms in the 3 acts. Currently, in this consolidated amendment bill that we are placing before the House, this is now being brought in. So auditors could have been acted upon till now, and they can continue to be acted upon even now per the 3 individual acts. But firms could not be touched. Whereas what we are bringing in here is that provision which will give them the ability to be able to touch the firms as well, not just the audit, in case of gross omission and commission, which they may want to take up. So the last few inputs, sir. The Quality Review Board, on that questions were raised as to why they should recommend cases to the Disciplinary Directorate. I think it was Rahul Shevale-ji who raised this question. I can't see him here. So ICAI, during consultations, wanted this provision. In course of review of quality audit reports sometimes, the QRB comes across irregularities in audit reports. Through this amendment, the QRB may refer such matters to Disciplinary Directorate to proceed against members of such auditors. So it is a provision which gives one more window for recommendation from the QRB for action to be taken. So I think it was member, I can't see whether he's here, Thomas Charikadan. Oh, yes, sorry. He had raised this question, sir, about bar councils and also these institutions now which are getting regulated. Is there a comparison of the disciplinary mechanism of the institutes like Bar Council, Council of Architecture, NMC, and so on? Sir, bar councils are not a monolith body. Since there are multiple state bar councils, having disciplinary committees in each state, unlike the chartered accountants, cost accountants, and the CS institutes. So multiple bodies exist already in them, not here. Moreover, these three institutes are performing all the functions together, including students' registration, enrollment, conduct of examinations, registration of members, licensing and regulation of their conduct, unlike the legal profession where multiple colleges exist. They can recruit, enroll students, train them, put them on, and then they become the member of Bar Council. Whereas here, that function, inclusive of profession, inclusive of discipline, everything is done by this one monolith. That's the essential difference, other than
of India is Madam.
So the Council of Architecture, sir, the Council of Architecture, sir, is constituted by the central government, and the disciplinary committee to inquire into the misconduct of architects has two non-elected representatives in it as members and one elected member, unlike the Council of CA, the cost accountants, and so on. So it already has that provision. Further, sir, the NMC Act, as was discussed above, prescribes for Sir, NMC Act, sir, which I have explained earlier, prescribes for state regulation and constitution of SMCs and the Ethics and Medical Registration Board to regulate the medical profession by the government. Whereas the CA, C&WA, CS Act prescribes for statutory self-regulation. That's the point I said at the very beginning, sir. The SRO, the self-regulatory organizations format itself has gone through rapid change globally. Sir, sure. So, there's this very legitimate question that CA firms should be aspiring to be big. Global Big Four is there. Can India not have a equivalent of a global Big Four? Honorable Prime Minister himself has been, while discussing with the institutions, engaging with them, saying, is it not possible for India to aspire to have one in the Big Four? So the government has enabled institutes, sir, to enter into mutual recognition agreements and MOUs of institutes from various different countries through various cabinet-approved approvals. The amendments like registration of firms will allow the audit firm to grow. So we have enough facility and provisions which we have brought in, wherein the big global firms can also be matched up by Indian firms which can come into play. Now you can't. I mean, you haven't seen it. At least in the last 70 years, we have not even found one large such firm which can compete. बिल्कुल, बिल्कुल, बिल्कुल. इसीलिए बिल्कुल. आदिर जी, आपको बधाई मैं दे रही हूँ. नहीं, अभी होगा ना. ये अमेंडमेंट के द्वारा होगा. बधाई दे रही हूँ आपको. पूरे
कोई जवाब मत दीजिए, आप तो आपका बोलिए.
सर, इस अमेंडमेंट के द्वारा और पिछले 7 साल में सरकार ईज ऑफ डूइंग बिजनेस के लिए जितने भी फैसिलिटेशन किया है, और मुझे बहुत आनंद हो रही है सर कि विपक्ष के नेता इसका सारांश पूरे समझ गया और ये बोल रहे हैं कि मोदी जी है तो मुमकिन है. बिल्कुल मुमकिन है सर.
So far as your contention is that where is Modi there is all. Even so, you don't have any.
माननीय मंत्री जी, आप उनके भाषण में अपना बोलते रहो ना, आप तो उनके वक्त पे क्यों सुन रहे हैं? नहीं, आप मैंने उनको अलाउ नहीं किया है अभी, तो आप क्यों? नहीं, आपकी सलाह की आवश्यकता है क्या?
आदिल जी के आवाज के लिए माइक की जरूरत नहीं है सर। मैं तो बैठ जाती हूँ बार बार आपके इंटरफियरेंस होने के बावजूद भी, फिर परमिशन लेता हूँ चेयर से।
मैंने परमिशन नहीं दिया आपको, आप तो बोलते रहे।
मैं कभी भी डंडा हूँ सर, इतना गर्माहट के लिए कुछ आवश्यकता ना होती है। रनिंग कमेंट्री होते रहते हैं, मुझे परवाह नहीं करती हूँ उसको सर। इसीलिए आई थिंक आई हैव ट्राइड आंसरिंग द इश्यूज रेज्ड बाय ऑनरेबल मेंबर्स। वेरी क्रिटिकल एंड वेरी क्रूशियल पॉइंट्स विच हैव बीन रेज्ड मैंने थोड़ा ज्यादा ही एलैबोरेट किया आपकी अनुमति लेकर के। मैं मानती हूँ ये समय के उचित अमेंडमेंट है। इससे चार्टर्ड अकाउंटेंसी, कॉस्ट अकाउंटेंसी और कंपनी सेक्रेटरी सब एक प्लेटफॉर्म पर आ जाएंगे और देश के इस डेवलपमेंट के रफ्तार में ये सब ऐसे प्रोफेशनली बेटर रहने में हमारे डेवलपमेंट का अच्छा स्पीड मिलेगा।
सी थॉमस जी, सी थॉमस जी।
Madam, I was referring about the chairman or the man who, the member who is heading the disciplinary committee. I was referring that in all the other professional bodies, Bar Council, Council of Architecture, and the medical profession, the disciplinary committee is headed by a member of the profession. But here the proposal is to have somebody else nominated by the government to head the disciplinary committee. That is where we differ. That is where the Institute of Chartered Accountants of India differ.
एक साथ देना। सोगत राय जी।
The minister gave a very cool and reasoned reply, for which I must thank her. But she did not mention that why in the past so many years, chartered accountancy firms, some with a global reputation, botched up the accounting in case of Satyam Computers. And later, in the case of infrastructure leasing and finance, ILFS. The minister has proposed some steps to discipline the chartered accountants. The minister has also stated clearly that we shall never be able to produce a Deloitte or a KPMG or a PwC or whatever. That is beyond our capacity. Now, I would like to know from the Honourable Minister, what are the specific steps? This law is not sufficient. The law was earlier also there to prevent chartered accountants from bloating the figures of companies so that they can cheat a trusting public. That harshness towards erring auditors was not audible in the minister's reply. But otherwise, she gave a very cool and reasoned reply, for which I must thank her again.
श्रीमती सुप्रिया सुले जी।
I appreciate you talking about the coordination committee, but my only question and concern is about the autonomy of this. You gave the example of IIT and IIMs. IIT and IIMs are institutions which are funded by the government, while chartered accountants and company secretaries, these institutions are not funded by the government. It's their own money. So doesn't this take away the autonomy? How can you compare this to IIT and IIMs is my only request. I still feel that the autonomy is being taken away and you should reconsider this point. Thank you.
N.K. Premchandan ji.
Sir, the basic issue which we have raised yesterday regarding the opposition to the bill is as far as the autonomy is concerned. So the conduct of the professionals should be judged by the professionals only. This is the principle which you have followed in almost all the independent professional bodies. But you have changed in National Medical Commission in National Medical Commission Act of 2019, even then you have changed. There also the majority of the disciplinary committee belongs to the profession, doctor's profession. Similarly, in the case of legal profession, as well as in the case of architecture, everywhere the professionals are judged by the professional. Their conduct is being judged by the professionals only. Why in the case of ICWA, Cost Accounting Institute, as well as Institute of Company Secretaries, why here alone the Ministry of or somebody who is being appointed or nominated by the Government of India? So I am an advocate. Yesterday also I mentioned I am an advocate. Suppose my conduct, my qualification to be a member of the Bar Council being determined by the ministry officials means what is the independence and autonomy of an institution? And also I fully support the observation made by Supriya Suleji. That is, all other organization Madam has mentioned is funded by the Government of India. This is absolutely the fund maintained by them, in which the Ministry of Corporate Affairs is coming into, and other officials which are being nominated by the government. That is why the question of autonomy is the main issue which we are raising. Kindly respond to that issue. Autonomy has to be protected. This is a suggestion which I would like to make. Thank you very much, sir.
माननीय मंत्री, आप तो बोल ली ना
सर. बात यह कि honorable minister was referring the example of US, UK, South Africa, etc. But the other tangible aspects and positive aspects being followed by those countries are not being abided by you in this legislative document. We have been arguing since last day that through this bill, the government has been making a subtle and deliberate attempt to consolidate the power and to snatch away the independence of the institutions by dismantling the autonomous framework of those concerned institutions. I am also, flagging the attention of the minister that there is an inherent flaw in this legislative document. The bill empowers the three councils to constitute multiple boards of discipline and disciplinary committees. However, the bill allows the central government to nominate the same person as presiding officer or members across different boards of discipline and disciplinary committees. This may be incompatible with the objectives of the speedy disposal of cases against members. Appointing the same set of people on multiple boards of discipline or disciplinary committees may prevent these entities from hearing cases of misconduct simultaneously. Thereby, it would lead delaying in disposal of cases. Madam, at least you should pay heed to us. Madam, at least you should pay heed to us. At least you should have paid.
Can I repeat all that you said? I did hear you. Don't worry. Nothing can distract me from Adhir Ranjan Chaudhary.
माननीय मंत्री जी, ओके माननीय मंत्री जी, माननीय मंत्री जी,
Sir,
माननीय मंत्री जी,
Honorable Speaker, sir, I want to assure, since he was so careful to watch me talking with the Honorable Home Minister, Home Minister was saying you must address all their concerns, haven't you? In the reply you gave, didn't you reply? Please do it now. So he's taken it up in your favor. So don't worry. I'm going to answer. I'm going to answer.
माननीय अध्यक्ष जी,
आदिर रंजन जी,
माननीय अध्यक्ष जी, मैं माननीय वित्त मंत्री जी से व्यवस्था की ही बात कर रहा था. मैंने बोला बिल के प्रावधान पर इतने सारे सदस्य चर्चा के समापन के बाद अगर चर्चा कर रहे हैं तो क्या आपने इसका रिप्लाई नहीं दिया है? तो इन्होंने कहा मैंने तो रिप्लाई दे दिया मगर शायद इन्होंने सुना नहीं है तो मैं फिर से दे दूं.
माननीय मंत्री जी, ये
आप बाहर थे, आप नहीं थे दानिश।
माननीय सदस्य, आप बैठे बैठे मत बोला करें, आपकी बहुत आदत खराब पड़ रही बीच बीच में, ये बता दो। नो, मैंने आपको कई बार कहा।
सर, मैं संक्षिप्त में सबके जवाब दे देती हूँ सर। सर, थॉमस टी चारीकरण, why should it be a non-professional heading? It's not the case in any other. But I think you also drew the reference, but the National Medical Council, I think the amendment was done in 2019. Medical Commission, thank you, Professor, has a non-member. So that is not to worry at all. And non-member is not going to undermine the professionalism. But certainly through this amendment, we are matching up with the global best practices where outsiders, which I've explained during my answer. So, Professor Saugata Roy, in his typical style, saying ILFS happened, you know, what is the experiences of ILFS, Satyam, you name it. I'll give you as many examples, where some of the big companies have been involved. Action has been, in a slow and steady fashion, being taken. But even there, a lot is left for all of us thinking it's not up to the mark, more should have happened. Actually, regulatory bodies have not taken enough step, is a thought which all of us share. So now, by not just the auditor, who I said for the public interest enterprises, where the NAFRA can do it, now the firms are also getting listed into it, so that if such a thing repeats, this provision, this amendment, which all of you all hopefully will pass, will empower these bodies to be able to bring these firms also to be answerable. And that is why this step is being taken. We are not letting firms move outside of the realm of regulation. This will bring them on board. So no such ILFS-like repetitions will happen. But in case, unfortunately, it happens, action on those who are certifying the accounts, be it a firm, be it an auditor, will be taken. That is the provision here. And I don't know if it was deliberate or if I've heard him wrong. I said we shall never, or something of that kind. I've never said any of that, sir. We shall never give autonomy, or some statement that Professor Saugata Roy, in his usual style, with a great affair. We shall never, that is, we as Government of India under Prime Minister Modi have given up saying India can never, we shall never have a Big Four equivalent, something of that kind. I'm sorry, sir, this kind of a cynicism, negativity never governs us. We are hopeful that India will certainly have a Big Four equivalent company, and these kind of amendments that we are bringing are going to facilitate that. And I'm sure Professor Saugata Roy will make sure that in Bengal there will be a good set of auditors who will have firms enough to grow to that size and that quality. I think your energies will be very much required in that direction. So then, Honourable Member Supriya Sule again questioned about autonomy, but I think that comparison is not right. It is, after all, their money. No, madam. If the Parliament of India hadn't passed the Chartered Accountancy Act and given them the authority, like the way Indian Institute of Management, Indian Institute of Technology are all given the authority with autonomy, unless that is given to them, they wouldn't be enrolling students, through which and through the fees that they earn, they have the corpus building up. So what is theirs? They have not put any equity capital into this firm. The Chartered Accountancy Institution is a result of the Parliament's Act. And that has given them all in one basket to enroll students, to train them, to certify them, and then to keep them in as a member to run the practice. All this is enabled by this House. So the money, like the way IITs raise, is a money enabled because of the Act of the Parliament. So please, otherwise you wouldn't have the ability to run the place. So, 1 minute. If you think No, I'll come. No, if you want me to quieten down, I'll quieten down. But if you're raising a conflict and also an argument with the... 1 minute, Thomas G. If you're raising a point on which you think I am wrong, I want to ask then, so is it that the Institute of Chartered Accountants is a franchise which is given by the Parliament? Not at all. It's a sacred... All right, sir. But I still say, without the Parliament Act giving them the autonomy and the authority, what's wrong if more people come into the business? You have a problem with that? Of course it is that. So their money, they're running it. Why do you come into it? Is the question being asked. I want more such companies to come, more such companies to regulate, more such companies to train students, sir. What is the objection here? Sir, there is no control, sir.
आप क्यों बैठ जाती हो?
Okay, sorry, sir. Sir, even here, the anxiety is that the disciplinary committee and the board of discipline is getting outsiders come into it. I've already read out details of how we are not getting into fees, management of their resources, enrollments, or even the way in which the elections and the governing body is run. Government is not getting into that. So just where we want to get in, and that is for the discipline, and having given the example which Professor Saugata Roy raised, ILFS, you didn't have any number. Satyam, you didn't have any number of people being under self-regulation punished. So if that body is getting people from outside, so that there can be better, transparent accountability on possible misdeeds, why is there such an agitation? You should welcome it, actually. So, sir, that was I think after that it was Adir Ranjanji saying, N.K. Premchandranji, who also spoke about the autonomy, the conduct that the judgment is being made on the conduct of the members by outsiders. The body also has chartered accountants in it. Body also has cost accountants to it. And a layperson, 2 laypersons in it. Where is the conflict here, sir? It's not complete group of laypersons sitting and judging a technical body. Just the entry of 1 or 2 is so agitating. Why should it? So, the judgment is first of all a wrong word there. It's a question of deciding on the discipline. And in that, laypersons are also being brought in who are professionals in their own areas of activity. And then the suspicion that it may lead to a regulatory capture because the Secretary of the government itself is sitting there of corporate affairs. Sir, we can always infer many things out of everything. Total autonomy was given for self-regulation. And we have honorable members themselves saying, after ILFS, no action. After Satyam, no action. After every big collapse, no action. So self-regulation, has it worked? It hasn't. Global best practices say it hasn't. And therefore, we need to have, I think RBI is doing a good job there, sir. Don't worry. He's the regulator for the bank.
Thank you. प्रश्न है कि विधेयक पर विचार किया
back again, sir, they've come to their own pals for whom they gave loans. UPA's time, loans were given to all these people, Choksis and Modis, who we are chasing and bringing back today. So Adir ji, back again, don't talk about it. I'll be tempted to talk about the damads and jijajis to whom you've given loans. So please don't tempt me to get back to that. Thank you, sir.
प्रश्न है कि विधेयक पर विचार किया जाए. जो सदस्य इसके पक्ष में हाँ गए हैं, जो सदस्य विरोध में